May it please the court, counsel. Obviously, this is a murder in the first degree and a abuse of corpse case. This argument is intended to be quite brief because the state understands that the court is well aware of the facts in the case, but I intend to highlight the evidence which the state contends proves all of the elements of murder in the first degree, as well as abuse of the corpse, which I'll deal with very briefly without PowerPoint at this point. One of the ways that a person can commit the crime of abuse of a corpse is to conceal it for the purpose, to hide a body for the purpose of concealing it. Obviously, the facts in this case support that, in that the defendant, by other evidence which I'll discuss, was the person who put Michele Jackson's body in that bin and moved it to a remote location in an attempt to conceal both her body and the underlying crime of murder in the first degree, which I'll now discuss. The court will understand that the elements of this crime are that on September 22nd, 2024, the defendant stabbed or cut Michele Jackson with a knife, that she died as a result of those injuries, that the defendant acted with malice aforethought, and the defendant acted willfully, premeditatedly, deliberately, and with specific intent to kill. So those are the elements which are the state's burden to prove. On element number one, which is essentially the identity element, the evidence in this regard is overwhelming. We have the defendant caught. I'm not sure his hands were red, but all his clothing was red, and hence our opening comment that he was caught red-handed. He was caught with the victim's scooter, which was also covered with blood, which had Michele Jackson's bloody shoe in it. He possessed her scooter. The murder weapon was located on the evening or early morning hours of September 23rd in his residence, covered in, we now know from the DNA testing, covered with Michele Jackson's blood, which was also smattered and smeared all over his residence. One of the towels in his home, also the towel was, we heard from our DNA expert, had both his DNA and Michele's DNA on it. The three-bladed knife, which he used, as you saw from the demonstration of exhibit number 45, which is the same knife we contend. He possessed both the handle in his trash can. The blade came in Michele's body. The second blade was found in his pocket, and the third blade was found at his residence in the case that knife is sold as a set in. So he is in in physical possession of two of the three blades, the third one having passed in and been retained in the body of Michele Jackson after and during the commission of this crime. I mentioned that Michele's blood is all over the house, and of course the defendant has what the court could reasonably conclude were injuries to his hands from having had the knife blades slip while assaulting and killing Michele Jackson. These are the pictures of all of those forms of evidence which I've just described, which are exhibits 3, 41, 27, 34, 20. Sorry, I won't read all the names or numbers of the exhibits, but what I'm displaying here are all the pieces of physical evidence which irrefutably tie the defendant to this crime and having been its perpetrator. The next element is, of course, that Michele Jackson died as a result of these stab and cut wounds. We just heard from Dr. Smith. It's essentially a completely uncontested element, which we have nevertheless proven by his testimony and by other evidence. The third and the fourth elements are both mental elements, the third element being malice aforethought. I'm not going to define it for the court because I think that would be condescending. I'm sure the court knows what that definition is, and then specific intent likewise is well defined and I'm sure understood by the court. Which, oh, I'm sorry, never mind the name. It's the wrong name. It should have been Michele Jackson. Malice aforethought. I will point out that malice aforethought is, under Iowa law, permitted to be inferred from the defendant's use of a dangerous weapon. Why is that? Malice aforethought is, among other things, is an evil or unlawful state of mind that exists prior to the commission of the act. And the fact that this defendant, or any defendant, chooses to use a dangerous weapon, which this knife certainly was, is perfectly good evidence from which to infer that he acted with malice aforethought. The nature and pure brutality of the injuries inflicted clearly demonstrate the defendant's evil and unlawful purpose in inflicting these lethal wounds to Michele Jackson. This was an unprovoked attack from behind. So that statement is supported by, among other things, the lack of any defensive wounds, the injury from ear to ear along her neck, I suppose could have been inflicted by a strike from the front, but there's no defensive wounds. The earbuds that she was wearing were both severed and found on the ground at the pavilion in the park. There's no indication that there was any sort of provocation from that could possibly explain the defendant's actions in this regard. The final element is that the defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill. With respect to the specific intent element, which it didn't sound from counsel's opening statement, was the contested portion of this. Despite that, what other conceivable intent could there be for anyone to have done what we all just saw was done to Michele, other than I'm going to kill her? Again, the law allows the court to infer from the defendant's use of a dangerous weapon that he acted with premeditation and specific intent. Again, very difficult to imagine how a person who did this could not have those states of mind. And I wish to point out that a motive is certainly lacking in this case. However, it's important to remember that an unknown motive is not the same thing as having had no motive. It's unimaginable what possible reason anyone could have to have done this, including the defendant. But our lack of ability to comprehend these sorts of acts does not mean that the defendant did not have one. Maybe he didn't have one, and I'm not sure which is worse, having one that at least he felt was a sufficient motive to do this, or lacking one. In either case, motive is not an element that we have to prove. What other intent than to kill could this defendant or anyone who committed these acts have? It's not conceivable. The defense argues, at least in opening, and perhaps will again, and I'm sort of pre-dealing with this because I don't intend to do a rebuttal argument, that there was no premeditation or deliberation because, at least in the form of the questions we heard of some of the witnesses, the defendant could have killed her elsewhere that would have been more private as opposed to out in the middle of an open park, and that somehow indicates that he didn't think about it in advance. He didn't think about the body being disposed of in advance because of his sort of haphazard selection of a neighboring trash bin, as opposed to having had an elaborate, well thought out plan, which of course the court knows is not what we mean, what the law means when we talk about premeditation or deliberation. It just means that at any point in time before the act is committed, the defendant has thought about it. It certainly doesn't mean that you can't be convicted of murder in the first degree unless you have the perfect murder plan and then you execute it perfectly. It certainly doesn't mean that. The defendant appears to have argued that he could have or perhaps should have used his car. That would have been a better way of disposing of her body. I would simply point out that the evidence appears to be that it was a rental car, so if he had a bloody body in there, he might have some questions to ask. So that particular argument doesn't hold much water. And perhaps they could have dumped the body in the cornfield. That was one of the questions, as opposed to wheeling it around and leaving it next to the field at the business at the edge of town. But I would point out for the court that the question is not, was he a great planner? The question is, did he think about killing Michele before he acted? That's what deliberation and premeditation means. And another tenet of Iowa law is that premeditation and deliberation need not exist for any particular length of time before the act. It just has to exist before the act. So, at least with that in mind, how the defendant acted after the murder is irrelevant to premeditation. Now, obviously the argument is made, well, if he'd been plotting and planning to kill Michele for a while, his plan would have been better. I guess that's the argument. But the question is what was in his mind before committing the act? That's the legal question and the factual question. So what evidence do we have about his premeditation and deliberation before he acted? We know that somehow he had to get close enough to Michele Jackson in order to inflict these injuries. If she was in the pavilion, he had to either get there or have already been there in waiting, one way or the other. We know that he had to have seen Michele somehow. We know that he had armed himself with a knife and perhaps the one blade that he still carried around when he was apprehended by the family later in the evening. We know that he had to quietly approach Michele because otherwise he wouldn't have been able to slash her throat so easily. And then once with that done, proceed to stab her 26 or however many times the expert indicated that he did that. We would also point out that I think the evidence supports a conclusion that many of those smaller wounds around her head, on her arm, came after the knife blade came out of her, and whether the defendant knew it or didn't know it, he continued to stab her, either not realizing the blade was there or not caring, and that's why you get these irregular shapes that were caused by the same knife stabbing her repeatedly. Once her neck had to have been cut by that point because the blade was out of the knife lodged in her back. The knife blade was obviously in the knife handle, for the slashing of the neck, for the first, we presume, it's reasonable to presume that the first stab to the back had the blade. The second stab to the back, the blade got stuck. The court can perhaps noted that the way these blades come out is by a push button along the blade handle, the knife part, and somehow that button got pushed and released that blade, and then when it was stuck in there, it wouldn't come out, and then continued to stab her over and over and over and over and over again. So he had to approach her and not be detected. He had to take out the knife. He had to arm himself with a knife. So how can anyone reasonably imagine a person who claims that perhaps, or argues, that I intended to kill her, but I never thought about it. It never entered my mind that what I was about to do before I did it was kill her. So one has to look at what the acts actually were to verify whether that's even conceivably possible. Sneak up, get the knife out, slash the throat. These are acts of somebody who has thought, even for a moment, about what he is about to do. And these are the acts that support the deliberation and premeditation components of the final element. A poor or spontaneous plan is not equivalent to no thought before acting. I'll repeat that. A poor or spontaneous plan is not the same as having not deliberated or premeditated before having killed her. And all the things that the defendant had to do before killing her to enable her to kill her are the proof that he had thought it out and did think it out and did execute it brutally. So as to the elements, as the state proven, the defendant repeatedly stabbed and cut Michele Jackson, yes. I have the wrong name, I'm sorry. Michele Jackson died as a result. The defendant acted with malice, and the defendant acted willfully, premeditatedly, with specific intent to kill. The state requests and submits that this evidence proves beyond any doubt the defendant is guilty of both crimes with which he is charged, and requests that those be the court's verdicts. Thank you.
Does the defense wish to give a closing argument?
Yes, Your Honor. Your Honor, just because the defense is very focused in this case on two of the required mental elements, that does not relieve the state of any of its burden of proof in this case. The burden on them is high on beyond reasonable doubt on all of those mental elements. And when you look at the facts that Mr. Prosser recited that show how the words that he used, Your Honor, I think was irrefutable, and how dramatically their proof is on the fact that it was Mr. Bevers-McGivney that killed Michele Jackson. It is that proof that equally supports the idea that there was no legally sufficient premeditation or deliberation in this case. So what I'm talking about with that, Your Honor, is everything that we talked about on cross-examination with Agent Thompson, the idea that when they are approached by, when Mr. Bevers-McGivney is approached by Annette Jackson and Sean Bachman, he has no good story about what he's going to say. There's no excuse that he's going to give that's going to hold up for why he's in possession of this scooter. The scooter has a bloody shoe in it that's been placed in there. It has no key in it. When they do go back to his apartment and search his apartment through the search warrant, it's obvious that there is evidence of this crime in there. It has not been dealt with in any kind of manner that would sufficiently conceal anything. We've got the knife just laying in a trash can with human hair material, blood still on it, obvious blood stains on the bathroom tub and the hand towel. I am not trying to say, and I'll forgive Mr. Prosecutor for arguing this. I'm not trying to say that you have to be Sir Arthur Conan Doyle to have premeditation in a murder. You don't have to sit down and be one of the great mystery writers and plan out the perfect murder to make it be first-degree murder. But in Iowa, there are requirements for what premeditation and deliberation require. The court's familiar with those. I know the court has given those instructions to juries many times over in other murder cases. But I'll state them. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. And to premeditate is to think or ponder upon a matter before acting. So those are really what the issues are here, Your Honor. And all of those pieces of evidence that show how haphazard and chaotic this was after the fact are absolutely relevant in looking at that. Mr. Prosser said that what happened after the murder is irrelevant to premeditation, and that, I think, goes against what the jury would be instructed on other similar mental elements. What I think the court knows when looking at evidence in any kind of case. If you were to look at the instruction on specific intent, it talks about you look, in order to determine someone's specific intent, which is a mental state of mind, you look at the surrounding facts and circumstances. It doesn't say that you look at what happened before the event only. You look at everything. You look at all of the possible pieces of evidence that weigh on that topic. So, you know, we could go through the list here of all of the things that just show that this was a very random, spontaneous, unplanned event, Your Honor. We've got physical evidence that is partially attempted to be accounted for with the bloody shoe at the scene, but leaving behind both the earbuds and the key to the scooter. A massive amount of blood on a paved area that is not going to just disappear. It's going to be easily seen by anybody who goes into that area. This haphazard idea that you're going to drag Michelle's body over and put it into one of these trash bins, and then take that across about at least a quarter of a mile or more through town, pulling it backwards through the street, as you saw on the video. And that's, he was moving slow on that video. If you look at Evan Thompson's video when he's walking the route that it was dragged, I believe it took him about 2.5 minutes, and he was walking at a brisk pace. And he's not dragging a loud plastic trash bin down the middle of the street at 10:30 or 11 o'clock at night. It's absolutely, none of this makes sense. None of it, you can't look at anything and explain why this happened, what is going on here. It just makes no sense. And Mr. Prosser, I talked about motive, and that's not really what I was talking about in my opening statement, but they don't have to prove motive. But the fact that there isn't any obvious motive here, there's no connection between these two of any kind of significance. We did submit Leilani Lynn's deposition transcript, and there was two brief things that she mentioned in it. One was one comment in about 8 months when he lived with Leilani Lynn, where she said out loud, "Oh, Michelle's over on the swings again," or something along that lines. And his response was, "Oh, really?" or something along that lines, just acknowledging what his aunt had said. And then some kind of program, like a church program or something that they may have been involved in when they were both young. That's it. There is no significant connection here. There would be no reason for him to harm her. There is no past history between the two of them. There's nothing that would give rise to this. It is truly senseless. And because it is so obviously senseless, it is those surrounding facts that support the idea that this was a spontaneous random act. Now, we did, in that deposition, there is also the testimony from her about what his childhood was like, And I told you in opening statement, we're not using that as an excuse. It is not a legal defense. We're not saying it could justify anything in this, but I think it sheds some light on it to what could cause someone to have long-lasting trauma and have an outburst that would precipitate something like this happen. It is not beyond it is reasonable to think that that might be there. When the court is looking at reasonable doubt as to whether or not there's the actual, not just the time for premeditation, or the time for deliberation, but was there actual deliberation? And so, you know, we've got no history there. We've got these, we talked with Evan Thompson on cross-examination about the fact that they seized a cell phone. There was no Google searches in there that would have caused any kind of alarm or concern. There's no pictures of her. You know, this is a very inexplicable act. Mr. Prosser, when he was going through his PowerPoint, he wanted to make it that Nathaniel is sneaking up behind, you know, over some distance and attacking Michelle from behind. Where's the actual evidence that that happened? They have no. He is not an expert. He gets to argue what he wants, but he is not a forensic expert at all. Yes, there was a lack of defensive wounds, but that does not mean that she was necessarily attacked from behind. They have no way of knowing that. There's no evidence in the record of that. There were several questions that I think it was more Mr. Prosser may have asked about different witnesses that live in the area about whether they could hear the swings squeaking when people were swinging on the swings. And almost everybody said yes, they could. Rusty swings, they make a lot of noise, you can hear those. But did we hear any witness that night who said they actually heard that night those swings squeaking? No. Okay, so the implication of that is that it is equally as possible that she was attacked when she got there. She didn't have, we have no timeline on this other than when the scooter is coming up the street and she's captured on that closed-circuit security camera going up the street towards the park. And then the next real event that we have is him dragging away the trash bin down the street later. We know that there is a bunch of effort in between those two events. Okay, we've got him trying to find the trash can. It's going to take him 10 or 15 minutes, one would presume. Again, I'm not an expert on that, but the court could see how slow he was walking backwards with that trash can, that he's got to walk that through town. He arrives back at his apartment at some point. Doesn't necessarily do much there. It looks like he probably washed his hands off because there's blood on that towel. But there's nothing done with the knife. He doesn't change his clothing at all. He goes back out. So if you're thinking that you're going to try to avoid being caught or detected or anything, you're going back out covered head to toe in clothing that's just matted in blood. It makes no sense. He goes back to the scene and only picks up some of the physical evidence that's there. His choice of how to deal with the body with this bin. He's got access to a car. Mr. Krause wants to say, well, then he's going to have questions to ask or to answer. Yeah, but he's going to have a lot more time to deal with that. He can drive the car to a car wash. There's lots of things that you can do other than getting stopped in the middle of the street covered head to toe in blood. So, you know, you look at all of this, Your Honor, and I think it cuts the other way. Their evidence that they, I'm not saying they phoned it in, and I'm trying to make sure that the court knows we're not just sitting back, oh, this isn't a fight. This is a fight. This is a fight on premeditation and deliberation, okay? And the evidence that they have that makes it so convincing and just irrefutable that he killed Michele Jackson is the exact same evidence that this court has to look at and say there was no deliberation or premeditation in this case. I'm going to again ask the court, and I know the court will. It goes without saying that the evidence is what the court is going to look at. I think that a lot of the emotion and the argument behind this case is the brutality of this situation. We do not pass moral judgments on making murder in the second degree, murder in the first degree. We rely on the proof before us, the evidence that the state has presented, and as Your Honor knows, in the definition of the instruction for beyond reasonable doubt, the lack of evidence or the failure of the evidence. And the issue with the state's case is that it's mostly speculation. They want to envision in their head this idea of him sneaking up from behind, that there's this stalking, but there's just no evidence of that. Your Honor. It could have equally have been, he comes around the corner from the outbuilding that's at the park there. She's right there. It happens. It's over. Your Honor, we would ask the court to carefully weigh that evidence, apply the burden of proof, the heavy burden that the state has, find the defendant not guilty of first-degree murder, guilty of second-degree murder, and count two.
Does the state wish to make a rebuttal argument?
Just briefly, I developed the same twisting of the brain listening to that argument as I do trying to understand the defendant's actions in this case. And the conclusion that I've come to, at least, is that there is no making sense of the senseless. There's no way. I challenge the court or anyone to look at this and say, how could this make any sense? How could this even happen? And the argument appeared to be that the defendant did these acts, that he did them specifically with specific intent. He did them with malice, but somehow he didn't think about it. He didn't deliberate, and he didn't premeditate. And I can't wrap my head around that. I don't understand in the real world how there could ever be a person to whom we could all look at and look at the evidence around and say, yes, I understand that. That makes sense to me, because that scenario makes no sense. And counsel argues that because this was such a senseless crime, that somehow that shows that there was no deliberation of premeditation. I don't understand that argument. I don't think that's, I think the senselessness of this crime shows that it was just a brutal, intentional, evil, malicious, murderous act that is itself senseless. And the fact that it was done badly and planned poorly, and he could have done other things, and he didn't take his clothes off, just means maybe that didn't matter to him. Maybe. What mattered to him was killing Michele Jackson for whatever reason he had. And after that, it was like, well, I'll try to get the scooter, and I'll put the knife back at the house, and maybe those water bottles were to try to clean up some of the blood. Who knows? Certainly not very effective means of trying to cover up what you just did, which there's obviously evidence of. But again, covering up what you've done has nothing to do with whether you thought about doing what you did before you did it. And I don't know how anyone gets around the conclusion that that's exactly what happened here. For those reasons, we ask the defendant be convicted of murder in the first degree and abuse of the court.
All right, this matter has been fully submitted to the court. The court is going to deliberate. It is the court's intention that at 1 o'clock it will deliver its finding of fact, conclusions of law, and verdict in order.